Thanks, Stephanie.
Anything to get you back on that.
Okay, it is 6:14 on Monday, November 21st. This is the study session. I'll call the meeting to order, and we'll start with the Pledge of Allegiance. Ready? Begin. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Yeah. So this is the study session tonight, and by board policy, we are required to do a training every 4 years on the Open Public Records Act and Open Public Meetings Act, and there's a couple of videos that we have to watch, and so to kind of keep us somewhat on task, we'll go out and move out to the audience, and Mr. Strong will be here momentarily. And I guess we can do the motion to excuse Mr. Mokel in the regular meeting. Okay.
Did you bring popcorn, Chef?
With me in this video is the Open Government Assistant Attorney General, Nancy Creer. This training video provides a basic overview of our Public Records Act for both records requesters and state and local agencies. It's intended to provide greater understanding of the legal requirements around the Act. The Public Records Act is a law created by an initiative vote of the people in 1972, which provides the public access to the records of government agencies. It received 72% of the vote. The purpose of the act is to provide the public full access to information concerning the conduct of government, mindful of individuals' privacy rights, and fulfill the desire for the efficient administration of government. The law is based on the principle that open government is essential to a free society. All state and local agencies must comply with the Public Records Act. All public records must be disclosed unless a law exempts records or information. There are well over several hundred exemptions. Some of those exemptions are listed in the Act, but many exist in other state and federal laws. The Act is a broad mandate interpreted in favor of disclosure, and its exemptions are narrowly construed.
This training presentation is based on the Public Records Act and the Attorney General's Advisory Model Rules. The rules are online at the Attorney General's website at www.atg.wa.gov. They provide examples of steps to comply with the Public Records Act. An agency may adopt any part of the model rules into its own rules. Local agencies should consult the model rules when establishing local Public Records Act ordinances. The model rules provide comments that are useful for interpreting the Public Records Act and for training agency personnel. The model rules are non-binding, but they are based on extensive outreach, court decisions, and have been cited favorably in some court cases. This training video was prepared in the fall of 2017. The model rules were being updated in 2017. The legislature also amended the Public Records Act in 2017, and the legislature can amend it again in the future. The courts can also interpret the Act. Consequently, and as a reminder, there may be developments in the law after this video is prepared. Several updates on the law are often posted in materials on the Attorney General's office website on the Open Government Training page. A PowerPoint on that page also provides training on the Public Records Act. This training video contains 16 short segments where we will review history, purpose, and intent of the Public Records Act, scope of the PRA, general obligations of an agency, what is a public record, requests for records, initial agency responses, reasonable estimates, adequate searches, disclosure, electronic records, managing broad requests, exemptions and withholding, fees, other records provisions, liability, and finally, additional resources. You have just heard from the Attorney General about the history, purpose, and intent of the Act. The Act regulates the disclosure of public records. The Act requires disclosure of public records unless a law permits withholding of a record or part of a record. The Act has many components, and compliance requires training. Training can be the difference between a satisfied requester and expensive litigation. The Act applies to both state and local agencies. A state agency includes every state office, department, division, bureau, board, and commission. A local agency includes every county, city, town, municipal corporation, special purpose district, and other forms of local government. In some cases, an entity which is not an agency can still be subject to the Act when it is the functional equivalent of an agency. This determination depends on whether it performs a government function, receives government funding, the extent of government involvement or regulation, and whether the entity was created by government. Courts are not subject to the Act. Agencies must appoint a public records officer responsible for being a point of contact for the public and for overseeing compliance. The name and contact information of the public records officer should be published with information on how to submit requests for records. The public records officer must have received training on the Act within 90 days of assuming his or her duties. Agencies must also publish information on the agency organization, rules, and procedures, and an index of specific categories of records. Agencies are required to adopt reasonable rules to provide full public access to public records, to protect public records from damage or disorganization, to prevent excessive interference with other essential functions of the agency, and to provide the fullest assistance to inquirers. Agencies may wish to consult with their attorneys when developing their rules and procedures. A public record is any writing relating to the conduct of government which is prepared, owned, used, or retained by any state or local agency, regardless of physical form or characteristics. It could be an email, text message, paper, letter, or memo, an audio or video recording, a picture, image, map, or any recording of information or data compilation from which information may be obtained or translated. A public record is not just what an agency creates, but includes documents created by citizens or private companies that are used or received by a government for a governmental purpose. A public record may also include documents not possessed by the agency, but which were used by the agency. For example, the courts have described that work documents on the personal computer, personal cell phone, or personal email account of an agency employee or official are subject to a request under the Public Records Act. Records of certain volunteers are excluded from the definition of public record. Records are excluded when they are not otherwise required to be retained and are held by volunteers who do not serve in an administrative capacity, have not been appointed by the agency to an agency board, commission, or internship, and do not have a supervisory role or delegated agency authority. Any person wishing to inspect or copy public records of an agency should submit the request to the agency, preferably in writing, using the agency's request form. The Public Records Act doesn't prescribe any official format for a valid request, so an agency must honor valid requests for identifiable records regardless of the format of the request. While using an agency's form is not required, it is typically the most efficient way to submit a request. A requester who chooses not to use an agency form must give the agency fair notice that he or she is submitting a request for public records. Agencies are required to honor requests received in person during an agency's normal office hours or by email. If an agency has adopted reasonable rules on how requests should be submitted, the agency may rely on those rules. The agency should be helpful to the requester in explaining how a request should be submitted and to whom. Records shall be available for inspection and copying upon request for identifiable records. So requesters should give a reasonable description of the records, enabling the agency to search for potentially responsive records. A request for all or substantially all of an agency's records is not a proper request for identifiable records. A request regarding a particular topic or containing a particular keyword or name shall not be considered a request for all of an agency's records. A request for information is not the same as a request for public records. The Public Records Act does not apply to requests for information. There is no duty to create a record that does not exist in order to fulfill a request for records or information. However, requests for information are at times easier to fulfill. Fulfilling a request for information may avert a large public records request. An agency must promptly respond to public records requests. Within 5 business days of receiving a request, an agency must respond. An initial response may be any one of the following: acknowledging receipt of the request and providing a reasonable estimate to respond, or fulfilling the request, or providing an internet address and link to the records on the agency's website, or seeking clarification while also, to the greatest extent possible, providing an estimate of time for further response if the request is not clarified, or denying the request with an accompanying written statement of the specific reasons. Reasonably clear requests for identifiable records may require no clarification. However, some requests are unclear. Seeking clarification permits the agency to identify responsive records, which in turn will aid in determining the scope of the request. Clarifying a request provides the fullest assistance to the requester so that the requester receives and pays for only those copies that are desired. Clarification may also result in prompt disclosure by identifying only those records desired. An agency should not seek clarification if the request is for identifiable records and is reasonably clear. If the entire response is unclear and the requester fails to respond to the agency's request for clarification, the agency need not respond to it. However, the agency must respond to those portions of a request that are clear. An agency may deny a bot request, which is a request that was automatically generated by a computer program or script when it is one of multiple requests from the requester received within a 24-hour period. The agency must establish that responding to the bot request would cause excessive interference with other essential agency functions. A requester is typically not required to provide the reason for a request, unless a law necessitates additional information from the requester. Agencies and requesters are encouraged to promptly communicate with each other if there are issues regarding a request. An agency's initial response to a public records request must provide a reasonable estimate for the time to respond when more time is needed. A reasonable estimate should account for many factors, including the time to have the requester clarify the request if needed, as well as time to assemble and review the records, provide notice to affected persons or agencies if needed, to redact exempt information, and to create a withholding or exemption log. An agency should not use the same estimate for every request. Rather, each reasonable estimate should be based on factors such as the complexity of the request, other pending requests, agency resources, and other agency essential functions. It's a good practice for an agency to briefly explain to the requester the basis for the estimate in the initial response. Extending the estimate is appropriate when circumstances have changed or additional information has come to light. Agencies are encouraged to briefly explain the need to revise an estimate. An agency bears the burden of showing that its search was adequate. Consequently, agencies should be able to document how a search was conducted and, for example, what search terms it used, as well as the location searched. An adequate search depends on the facts of each request, but it is one that is reasonably calculated to uncover all responsive documents in whatever form, paper or electronic. An agency must make more than a perfunctory search and follow obvious leads as they are uncovered. The search should not be limited to one or more locations if there are additional places where responsive records are likely to be found. If responsive public records are likely to be found on or in an agency employee's or official's personal device or account, the employee or official must search those devices and accounts for responsive records. It is possible to conduct an adequate search and still not locate a responsive document. However, if a responsive record is not located and/or if challenged in court, the agency will have to prove its search was adequate. An agency must make records available during its customary office hours for a minimum of 30 hours per week. Public records are presumed to be open for inspection and copying unless a specific law exempts the record or information from disclosure. Agencies can deliver copies of records to a requester in a number of ways, such as providing links to the records that are on the agency's website, providing paper copies of paper records or scanned copies of paper records by mail or making them available for pickup, or providing electronic records by various methods. You may recall that with respect to what is a public record, the Public Records Act does not distinguish between paper and electronic records. Most agencies create records in an electronic format. A copy of an electronic record should be produced in the requested electronic format if reasonably feasible. Translating a record into an alternative electronic format at the request of the requester, or scanning a paper record, is not creating a new record. Metadata is information embedded in a document that provides detail about the document's characteristics. This may include information such as when the document was created, edited, recipients, and so forth. Non-exempt metadata must be disclosed when expressly requested. When agencies obtain new technologies, they should consider not only the agency's business operation needs, but also records retention and disclosure requirements. Examples of such technologies are portals through which records can be requested and delivered, electronic redaction tools, or retention software, just to name a few. In addition, agencies can look at whether they could make use of their current technology more robust. The legislature encourages agencies to make public records widely available electronically, particularly commonly requested records. For example, an agency could make commonly requested records available on its website. Then, as noted earlier, an agency could fulfill its obligation to provide access to a public record by providing a requester with a link to a specific agency webpage containing the electronic copy of the requested record. For requesters without access to the internet, an agency could provide a computer terminal at its office. Agencies should develop policies addressing technology concerns, such as if and when agency employees may use personal devices for public agency uses, and what responsibilities and requirements therefore attach to the employee. An agency may receive a broad request that asks for any and all records related to a topic. Agencies may not deny a request solely because it is overly broad. As noted, a request for all or substantially all of an agency's records is not a valid request. But a request for all records regarding a particular topic or containing a particular keyword or name is not a request for all of an agency's records. After an initial search shows there are potentially hundreds or thousands of different types of responsive or potentially responsive records, a public records officer should contact the requester to explain the estimated total number of records that would need to be searched, or provide other information describing the anticipated scope of the search. Then the agency could seek clarification to ask if the requester wants all of the different types of responsive records and is willing to pay for all the copies, or instead, if the requester is seeking only some of the records. Good communication can assist both the agency and the requester. A broad request will usually result in a longer estimate of time for disclosure, as well as producing records in batches or installments. When seeking clarification, to the greatest extent possible, the agency must provide a reasonable estimate of time the agency will require to respond to the request if it is not clarified. In many instances, a requester will narrow the scope of the request to enable the agency to provide disclosure more promptly and less expensively. An agency may manage broad requests in a couple ways. An agency may require a deposit in an amount not to exceed 10% of the estimated cost of providing copies for a request. If an agency makes copies in response to a request available on a partial or installment basis, The agency may charge for each part of the request as it is provided. If an installment of a records request is not claimed or reviewed, the agency is not obligated to fulfill the balance of the request. Finally, use of electronic technologies to search, review, redact, and disclose public records can reduce overall costs of compliance for agencies. Agency responses denying in whole or in part inspection or copy of any public record shall include a statement of the specific exemption authorizing the withholding of the record and a brief explanation of how the exemption applies. Exemptions exist throughout the Public Records Act and other state and federal laws. Common exemptions include information such as personal information in files maintained for agency employees, if private, pending investigative files compiled by law enforcement or agencies with authority to discipline members of a profession, the non-disclosure of which is essential to effective law enforcement or for the protection of any person's right to privacy, educational records of students in public schools, attorney-client privileged information or work product related to litigation, or protected healthcare information. There is no statute providing a general privacy exemption. If privacy is an express element of a specific exemption, it is only invaded if disclosure would be both highly offensive to the reasonable person and also not of legitimate concern to the public. Exemptions in the Act must be construed narrowly. The general rule is that an agency redacts or withholds only the exempt information and produces the non-exempt information. An acceptable way of providing this information to the requester is with a withholding index, often called an exemption log. The information provided as part of the log should include a description of the type of record or part of record denied. The description should include identifying information from the document. For example, whether the document is a letter or email, the date the document was created or other relevant date, the total number of pages, and the sender and recipients. The exemption log must also include the statutory authority making the information exempt and a brief explanation of how the exemption applies. Some of this information will be evident on the face of the document where redactions have been made to only part of the document. An exemption log, the written explanation, also may be provided in different formats. For example, may be handwritten or compiled in a spreadsheet or chart, or in a letter, or redactions are marked on the records with exemption codes, and the requester is given the key to the codes. The format of the exemption log or exemptions is not relevant so long as the required information is provided. Any person may inspect non-exempt public records for free. An agency may not charge for the time of staff to search, review, or redact public records when preparing them for inspection. If a requester wants copies of records, an agency has options to charge for copies. It can charge actual costs, or it can charge default fees listed in the Public Records Act, or it can charge an alternative up to $2 fee for an entire request. Some other provisions may be relevant too. In order to charge actual costs, an agency must make available for public inspection and copying a statement of the actual per page or other costs and how it determined actual costs. An agency may adopt its statement of actual costs only after providing notice and a public hearing. When calculating fees, the agency must use the most reasonable, cost-efficient method available to the agency. Staff time to copy and deliver the requested public records may be included in an agency's costs, but an agency may not include staff salaries, benefits, or other general administrative or overhead charges unless those costs are directly related to the actual cost of copying the public records. An example of when an agency may want to charge for the actual costs of staff time is where an agency scans paper records and copies them into an electronic format. The charges should be reasonable and related to the wage of the person likely to be repeatedly assigned to this task. If an agency does not have staff available to make copies, for non-exempt records, an agency may send a scanning or copying project to an outside vendor and pass on the actual cost to the requester. Electronic copy costs may include the actual cost of the electronic production or file transfer of the record, the use of any cloud-based data storage processing service, and the cost of transmitting electronic records, including the use of a physical media device. A second method to charge copy costs is for an agency to choose to use a statutory default fee schedule provided in the Act. In that case, an agency need not calculate actual costs if it has rules or regulations declaring the reasons doing so would be unduly burdensome. The statutory default fee schedule lists, for example, per page costs for paper records, scanned records, and costs for electronic records. As yet another alternative, an agency can assess an up to $2 flat fee for an entire request when certain conditions are met. The Act includes other fee provisions. For example, an agency cannot charge for access to or downloading of records it routinely posts on its website prior to the receipt of a request, unless the requester has specifically asked that the agency provide records through other means. An agency may impose the actual cost of a customized service charge when the request would require the use of IT expertise to prepare data compilations, or when such customized access services are not used by the agency for other business purposes. The agency must notify the requester and take other steps if it chooses to do a customized service. An agency can require an advance 10% deposit before making copies. An agency may enter into a contract, memorandum of understanding, or other agreement with a requester for an alternative fee arrangement, or in response to an extensive or frequently occurring request. An agency may choose to waive any charge pursuant to agency rules and regulations. Upon request, an agency must provide a summary of the applicable charges before making copies. The requester then may choose to revise the request to reduce the number of copies and the cost. In sum, the Public Records Act provides an agency several options for assessing charges for copies. The choices selected may vary from agency to agency. Under a different law, the records retention laws at RCW 40.14, agencies must maintain a log of public records requests, including for each request, the identity of the requester if provided, date of receipt, text of request, description of records produced, description of records redacted or withheld and the reasons for doing so, and the date of final disposition. With respect to the identity of the requester, it is possible an agency received only an email address from the requester, and if so, that address would be included in the log. The logs must be retained per the agency's records retention schedule and are a public record. The records retention law also provides that agencies spending at least $100,000 to fulfill requests during the prior fiscal year must report 17 data points about their PRA requests to the Joint Legislative Audit and Review Committee. Under the Public Records Act, any person having been denied an opportunity to inspect or copy a public record may seek further review in the agency. The person may also file a lawsuit to enforce his or her right to access public records. A requester can also file a lawsuit if he or she believes that an agency has not made a reasonable estimate of the time or of the charges to provide public records. Such a lawsuit is to be filed in a court within 1 year of an agency's final definitive response to a request, such as a final claim of exemption or the last production of public records on an installment basis. The agency has the burden of proof to demonstrate that public records were lawfully denied or its estimates were reasonable. If it does not make this showing, an agency will pay the requesters reasonable attorney's fees and costs and may pay potential penalties for denying records in violation of the Public Records Act. A court will consider mitigating and aggravating factors in determining a penalty amount. Lawsuits for public records can be extremely time-consuming and expensive for agencies. Understanding and correctly applying the law is a good risk management tool for state and local government. In rare cases, individual employees may also be civilly or criminally liable under other laws. State agency employees and state officers are subject to the Ethics in Public Service Act. It is a violation of that state ethics law for a state employee or officer to intentionally conceal a public record required to be released under the Public Records Act. State agency employees and officers may be fined up to $5,000 per violation of the state ethics law. It's also a crime for any agency officer to willfully mutilate, destroy, conceal, erase, obliterate, or falsify any record of that agency's office, except where the law expressly authorizes the non-disclosure or destruction of records. The crime is punishable by imprisonment of up to 10 years or a fine of up to $5,000 or both.
Thank you for participating in the Attorney General's Open Government Training. For more information, there are available resources for agencies to receive training and technical assistance for compliance with the Public Records Act. An employee should first consult with its agency's public records officer for routine assistance or training. Additional resources are listed on this website. The Assistant Attorney General for Open Government is also available to provide information about the Public Records Act. Thanks again for watching.
Hello, I'm Assistant Attorney General Morgan Damerow. This training provides an overview of the Open Public Meetings Act. It's intended for both the public and public agencies. Our purpose in this training is to provide a greater understanding of the legal requirements of the Open Public Meetings Act. The Act was passed in 1971, a time of a nationwide effort to make government affairs more accessible and more responsive. The purpose of the Act is to provide the public access to information concerning the conduct of state and local government. The law is based on the principle that open government is essential to our free society. The Open Public Meetings Act gives the people of Washington State the opportunity to witness the deliberations and decisions of government. More recently, that's included an opportunity to provide public comment as part of that process. Multi-member governing bodies of state and local agencies such as school boards, city and county councils, and the state commissions must comply with the Open Public Meetings Act. The law states that it is intended that the actions of these governing bodies be taken openly and that their deliberations be conducted in an open manner. Meetings subject to the Act must be open to the public, gavel to gavel, unless the law permits a meeting or part of that meeting to be closed. Thank you for watching, and I hope you find this training informative. This training's purpose is to increase your knowledge of the Open Public Meetings Act. The OPMA is in Chapter 4230 of the RCWs, and this training incorporates updates from the 2022 legislative session. This training video contains 15 short segments. We just discussed Section 1, the history, and Section 2, the purpose of the Act. The remaining segments we will review the scope of the OPMA, what is a governing body, what is a meeting, what is action and final action, travel and gathering, regular meetings, special meetings, remote meetings. We'll also talk about executive sessions, public attendance and comment, minutes, liability, as well as other laws and provide some additional resources to assist you. The Act has several clear requirements and compliance with them is improved with training. Training can mean the difference between meeting your agency's OPMA obligations and expensive litigation. The Act applies to governing bodies of multi-member public agencies, both state and local. At the state level, public agency includes state boards, commissions, committees, departments, educational institutions, or other state agencies which is created by or pursuant to statute. Public agency does not include the courts or the legislature. For local governments, public agency includes any county, city, school district, special purpose district, or other municipal corporation or political subdivision of the state of Washington. Examples of these include city councils, county councils, school boards, and fire district boards. Public agency may also include a sub-agency of a public agency, which is created by or pursuant to statute, ordinance, or other legislative act. A good example of these includes planning commissions, library or park boards, or commissions. A final group is any policy group whose membership includes representatives of publicly owned utilities formed or pursuant to Washington laws when meeting together or as or on behalf of participants who have contracted for the output of generating plants being planned or built by an agency operating them. In some cases, an entity which is not an agency may still be subject to the OPMA when it is the functional equivalent of a public agency. This determination depends on whether it performs a governmental function, receives governmental funding, the extent of governmental involvement or regulation, and whether the entity was created by government. Some activities of public agencies are not subject to the OPMA. They include certain licensing and permitting activities, quasi-judicial matters, matters governed by the Washington State Administrative Procedures Act, and certain collective bargaining activities. All meetings of the governing body of a public agency shall be open, and the public and all persons shall be permitted to attend any meeting of the governing body of the public agency, except as otherwise provided in the OPMA, such as during a declared emergency. A governing body is defined as a multi-member board, commission, committee, council, or other policy or rulemaking body of a public agency, or any committee thereof, when the committee acts on behalf of the governing body, conducts hearings, takes testimony, or public comment. Agencies governed by an individual, such as a single director, are not subject to the OPMA. Meeting means meetings at which action is taken. Physical presence of the members is not required. A meeting can occur by phone or in some cases by email. I will talk more about email exchanges later in this training. A meeting does not need to be titled meeting. The OPMA also applies to retreats, workshops, and study sessions. In order for there to be a meeting, there must be a quorum of the governing body. A meeting does not occur if there is no quorum. We have talked about the fact that the OPMA applies to a governing body at a meeting. In order to qualify as a meeting, the governing body must take action. Action means the transaction of the official business of a public agency by a governing body, including but not limited to receipt of public testimony, deliberations, discussions, considerations, reviews, evaluations, and final action. A subset of action is final action. Final action means a collective positive or negative decision or any actual vote by a majority of the members of a governing body when sitting as a body or an entity upon a motion, proposal, resolution, order, or ordinance. Final actions must occur in public. Secret ballots are not allowed. A majority of the members of a governing body may travel together or gather for purposes other than regular meetings or special meetings, so long as no action is taken. And remember, action includes discussion of agency business. This means a quorum of members can travel to a meeting together, or they can gather at a public or private event, such as a festival or social function, so long as they do not collectively discuss agency business or matters. In the next segment, we are going to talk about the types of meetings where a governing body may meet. The first is regular meetings. Regular meetings are recurring meetings held in accordance with a periodic schedule by ordinance, resolution, bylaws, or other rule. State agencies file these notices of regular meetings each year with the Office of the Code Reviser. Regular meeting agendas are to be posted online on the agency's website 24 hours in advance. A special purpose district or city or town is not required to post an agenda online if the agency has an aggregate valuation of property in the taxation district of less than 400 million, a population of less than 3,000, and provides confirmation to the state auditor when filing its annual report that the cost of posting notices to a website would exceed 0.1% of the agency's budgets. These provisions exempting very small agencies changed in 2022. Certain notice requirements are required for special meetings. These include written notice 24 hours in advance of the meeting, provided to members of the governing body unless waived. The notice must be provided to local newspapers, radio, and TV stations that have a request on file with the agency. The notice must also be posted on the agency's website if it has a website. There is an exception for very small agencies, agencies with no FTEs or with no one whose job responsibilities, either by job description or by contract, with the responsibility to maintain or update the agency's website. The notice must be prominently displayed at the main entrance site and the meeting site unless the meeting is being held as a remote meeting or one where some or all members of the public are limited due to a declared emergency. The remote meeting provisions are new, and we'll be addressing those in just a moment. The notice must specify the time, place, and business to be transacted. Unlike regular meetings, where the agenda may be changed and final action taken on a matter which was added to the agenda, under special meetings provisions, the governing body is prohibited from taking final action on any issue not on the original notice. There is an exception to the notice requirement for emergency special meetings. Those are meetings involving injury or damage to persons or property, or the likelihood of injury or damage, where time requirements make notice impractical and increase the likelihood of injury or damage. New in the OPMA through the 2022 amendments are provisions addressing a governing body holding remote meetings. After the declaration of emergency by a local or state government or agency or by the federal government, and the agency determines that it cannot hold a meeting of the governing body with members of the public in attendance with reasonable safety, the agency may either hold an all remote meeting without a physical location or hold a meeting with the governing body present but some or all of the public excluded. In either of these instances, the agency must provide an option for the public to listen telephonically or by using a readily available alternate means in real time, such as an available television cable broadcast or the internet. Any option selected may not require any additional cost to access the program. If the agency does not provide an option, the agency is prohibited from taking action except for an executive session as authorized under the OPMA. If your agency is holding an all remote meeting with some or all of the public excluded, the notice of the meeting must include instructions on how the public may listen live to the meeting. An agency that held some of its regular meetings remotely prior to March 1st of 2020 may continue to do so with no declared emergency, so long as the agency provides an option for the public to listen as required for emergency remote meetings. Up to now, we've been talking about all the requirements to ensure openness and transparency. Under the OPMA, there are enumerated instances where the governing body may convene outside of the public's view in executive session, or if the governing body is discussing matters not subject to the OPMA. An executive session may occur as part of a regular or special meeting. The grounds for holding an executive session are limited to the purposes listed in the OPMA and are narrowly construed. The purpose of the executive session and the time it will end must be publicly announced before excluding the public, and the time can be extended by further announcement. Examples of purposes include certain real estate transaction discussions, reviewing negotiations on publicly bid contracts, evaluating the qualifications of an applicant for public employment, and meeting with legal counsel regarding enforcement actions, litigation, or potential litigation. The OPMA provides a list of authorized executive session purposes at RCW 4230-110. An agency must carefully follow the law when meeting in an executive session. For example, when meeting in an executive session under the OPMA to discuss agency enforcement actions, litigation, or potential litigation, there are 3 requirements. First, legal counsel representing the agency must be present. Second, the purpose is to discuss an agency enforcement action, litigation, or potential litigation to which the agency, governing body, or a member acting in official capacity is a party or is likely to become a party. And finally, public knowledge regarding the discussion is likely to result in an adverse legal or financial consequence to the agency. Remember, an agency can discuss only those matters in an executive session under the OPMA that it has told the public it would discuss. The members cannot talk about other topics in that executive session. In addition to an executive session, a public agency can have a closed meeting to discuss matters not subject to the OPMA, such as deliberating on a quasi-judicial matter or collective bargaining. Other laws may provide additional procedures or authority for particular meetings or hearings to be closed to the public. There may be additional laws for particular agencies as well. As we discussed, all meetings of the governing body of a public agency shall be open in public, and all persons shall be permitted to attend any meeting of the governing body of a public agency, except as otherwise provided in the OPMA, An agency also cannot place conditions on attendance, such as requiring persons to register their names or fill out a questionnaire before attending. This provision does not prohibit any generally applicable condition determined by the governing body to be reasonably necessary to protect public health or safety, or to protect against interruption of the meeting, including a meeting at which the physical attendance by some or all members of the public is limited due to a declared emergency. As noted, email or phone call discussions amongst members of a governing body can be a meeting under the OPMA. But the purpose of the OPMA is to permit the public to attend and observe agency meetings. So when the public is unable to attend email or phone call discussions that are meetings under the OPMA, the act has been violated. Recent amendments to the OPMA make it clear members of a governing body can participate in meetings remotely with no declared emergency. However, public attendance must be maintained. In doing so, it is generally agreed that public notice procedures must be satisfied, and the agency has to set up a process for the public to attend, such as a speakerphone available at the agency's official meeting location, so the public can hear the discussion. In contrast, since an email exchange amongst a quorum of the members of a governing body is not open to the public, such an exchange in which an action is taken is a meeting that would violate the OPMA. And remember, action is broadly defined. It is very difficult to envision a way in which those email exchanges comply with public notice or attendance requirements for a regular or special meeting. One of the 2022 changes to the OPMA is a requirement that public agencies receive public comment at or before every regular meeting at which final action is taken. The 2022 amendments allow agencies to accept public comment either by written format or orally. If the governing body chooses written public comment, it can be submitted before or at the meeting. Any written comment received must be distributed to the governing body. The governing body may set reasonable deadline for submission prior to the meeting. The oral comment option is very similar to what many agencies were doing voluntarily before the 2022 amendments. Agencies can put reasonable procedures in place to allow for public comment. This may include limits to the time available for public comment or limit comment to those topics on the agenda. However, a governing body may also choose to accept public comment on any topic. If oral public comment is taken by the governing body, it shall, when feasible, provide an option for remote public comment for individuals that have difficulty attending. Difficulty attending may be due to a disability, limited mobility, or for any other reason that makes physical attendance difficult. A governing body is not required to accept public comment that renders orderly conduct of the meeting unfeasible. The OPMA has procedures for dealing with disruptions where orderly conduct of the meeting is unfeasible. The minutes of all regular and special meetings, except executive sessions of such boards, commissions, agencies, or authorities, shall be promptly recorded, and such records shall be open for public inspection. The OPMA does not require an audio or video recording of a meeting. Many agencies choose to do so. Public agencies are encouraged through the 2022 amendments to make audio or video recordings of meetings, or to provide an online streaming option of all regular meetings of the governing body, and to make any recordings that the agency does make available online for a minimum of 6 months. Violations of the OPMA can result in a lawsuit against an agency and its members. A court can impose a $500 civil penalty as personal liability against each member who knowingly violates the OPMA, and a $1,000 penalty for a subsequent knowing violation. A court can also declare any action taken at a meeting not held in compliance with the OPMA null and void. And a court will award costs and attorney's fees to a successful party seeking a remedy under the OPMA. To recap, this presentation covers the highlights of the OPMA. Public agencies may be subject to other laws governing other particular meetings, hearings, procedures. Some agencies have particular laws that govern their meetings as well. Like the OPMA, the laws concerning agency meetings and hearings can also be amended from time to time. Therefore, agencies are cautioned to be mindful of all current laws concerning their meeting and hearing procedures. Thank you for watching the Attorney General's OPMA training. For more information, there are available resources for agencies to receive training and technical assistance for compliance with the Open Public Meetings Act. An official should first consult with his agency's counsel for routine assistance and training. Additional resources are listed on this website. The Assistant Attorney General for Open Government is also available to provide information about the Open Public Meetings Act.
Okay, can everybody hear me? I'll wait for the microphone. We'll go ahead and adjourn. Is there any other business as far as the study session goes? If not,
I have a couple questions.
sure, go
Who
ahead.
is our public records clerk?
I believe it's Tracy Cox. I did check the procedures, and there is some, it needs to be updated. So we'll check with Joe Conley and how he wants to have that handled.
Okay, and it seemed to say two different things. If someone comes in and wants some records and they go through the procedure and all that, we're gonna charge them for copying costs.
Mhm.
So it seemed fuzzy to me. Can we, or do we, or don't we charge them for the time it takes a person to copy? Do we charge them for their time of labor? Yes or no, or not?
We'll have to check and get back to you. My understanding is we have a rate that we charge, but I'm not sure if the rate, I'm not sure what all is included in that rate. So we'll get that information for you.
I heard both sides.
Right.
Yes, you can, no, you can't. My last one is, we were at before school one year, we had a thing down at the skill center
Mhm.
before school starts with the principals and directors, and we were all invited, but and it happened that three of us came in for the morning session, and one of us had to leave. But if we were at a meeting and we're all three sitting in different areas of the room, from the way this sounds, why couldn't we all stay?
That's a good point. If there's not discussion by the board at that meeting, then it would not be considered, taking action, like they said, having discussion. So good point.
We could have stayed.
Yeah.
Thank you.
Okay, if there are no further questions, we'll adjourn the executive session and,
Study session.
I'm sorry, the study session, and go ahead and start the regular meeting. We'll call the meeting to order at 7:06 PM, and we will start with the Pledge of Allegiance again. Ready, begin. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay, and before we get going, I noticed Mr. Mokel is not here. Is he to be excused from today's meeting?
Yes, he asked us to please excuse him.
Okay, was that taken care of in the study session? So would someone like to make a motion to excuse Mr.
I'll move
Mokel?
that we excuse Mr. Mokel from this regular meeting.
Thank you, Mr. Meyer. We have a motion. We'll go ahead and vote. All those in favor signify by saying aye. Aye. Opposed, same sign. Motion carries 4-0. Any changes to the agenda?
Yes, we'll add a number 14, executive session, performance of a public employee.
And we'll move adjournment to item 15. And All right, discussion items, WASDA training, open government, oh, I'm sorry, I'm on the wrong one there. Response to public comment.
Yes, at the last board meeting, November 8th, there was a parent of a high school student who asked for some clarification regarding Ramstrong. Ramstrong is the advising class at the high school. So the response is that Ramstrong is graded pass, no pass. The high school principal reviews teacher grading practices with the expectation that there is at least one assignment in the grade book per week. And just like other classes at the high school, there's not an expectation of a daily assignment to be included in the grade book. So that concludes the response with public comment.
All right, thank you, Dr. Finch. Next item, 5B, staff recognition, retirement recognition.
Okay, we wanted to have an opportunity to recognize Cindy Cook. She served for 26 years with the West High School District as a paraeducator. Most recently, she was the library parapro at the middle school. I don't think she's here this evening, but we sure appreciate Cindy's service throughout the years, and we want to make sure we recognize that in the minutes.
Thank you, Dr. Finch. We'll move on to item 6, program presentation, early literacy screener, risk factors for dyslexia.
All right, this is an opportunity for the board to hear from our coordinator for state and federal programs, Geraldine Ashbaugh. She's been working with the instructional coaches at each of the elementary schools to make sure that we are complying with the state law that requires early literacy screening and gives us highlights for the risk factors for dyslexia. Knowing that as school personnel, we do not diagnose dyslexia, but we are able to do an early literacy screener and make referrals to families. So I believe she has a PowerPoint presentation for us, so we'll have the board join the audience so we can see the PowerPoint.
Except for this is much later. All right. Okay. All right, so I'm going to go ahead and get started. Again, I'm Geraldine Ashbaugh, State and Federal Coordinator for the district, and I'm here to update you on the early literacy screener that we are using to identify areas of weaknesses in reading and risk factors for dyslexia. So in compliance with state law, we are one of several Washington school districts who were required last year in the year 21-22 to implement the early literacy screener, to implement full implementation of the screener. So I spent a good year and a half with the instructional coaches, really looking at what that involved and outlining that for the district. The purpose of the early literacy screener law is to really look at risk factors for dyslexia. And we do that by identifying reading weaknesses, or I like to say areas for growth, right? So strength space there. But just wanted to review the definition of dyslexia. Dyslexia is a specific learning disorder that is neurological in origin and that is characterized by unexpected difficulties with accurate or fluent word recognition and by poor spelling and decoding abilities that are not consistent with the person's intelligence, motivation, and sensory capabilities. I'm going to dig out my notes here. I'm sure I'm going to forget something here, but I'm really thankful that we have the iReady diagnostic already in place in West Valley School District, because it really does cover 3 of the components that are part of the early literacy screener. So when I'm looking at the iReady diagnostic and the work that I do with our learning assistance program and our Title I programs, K-8, I'm looking at students across the district, K-8, and I'm able to take their scores and rank order them and come up with a cut score across every grade level to identify students who need extra support in reading instruction. What the early literacy screener does is it really hones in on those 3 other components: phonemic awareness, phonological awareness, and letter sound knowledge at the K2 level. So we look at our diagnostic, we look at those skill areas, and if necessary, then we go on to provide the next assessment, which is the RAN. So that is the part that is added. That's the rapid automized naming assessment.
And within that assessment, we are able to assess the ability to quickly name aloud a series of familiar items. And actually, I typed these kind of backwards. It kind of starts with objects and then colors and then numbers and letters. So if students are able to identify the objects on a given page, then that's an appropriate piece of the assessment to give them. And we put the task card in front of them and we time them and we ask them to name the objects, and we time them and we ask them to name the colors. And we're able to get a standard score out of that assessment and use their age equivalence and scale score, percentile rank, all that stuff to determine whether they are average, above average, below average on the rapid automizing naming assessment. So when we're looking at the rapid automizing naming tasks or the assessment, we're really looking at measuring our brain's ability to connect visual and linguistic processes to name what we see in a rapid and automatic way. It's an early assessment for fluency before we are actually word reading. Students are actually word reading. And rapid automized naming cannot be pre-taught or remediated. Therefore, it's not an area that we'll progress monitor. So again, that's the component of the assessment that really helps us to see if students are in need of different forms of intervention. As a school district, we are required to provide interventions using evidence-based multi-tiered systems of supports. That's what the MTSS stands for. So as often as possible, those tier 1 supports start in the classroom. And this is where I need my notes because I know I'm not going to worry about it. So tier 1 supports start in the classroom. We want them to be extensive and cumulative with lots of opportunities for students to have exposure. Research shows that some kids need up to 25 exposures to a concept in order to get it, where many students need only 1 to 5 exposures. So tier 1 supports, we're really looking at providing more exposure to the concepts for students. If a student is still not getting the concepts or they are still struggling, the general ed teacher would work with a team to determine other interventions. Maybe that's an increase in instructional time. Maybe it's a smaller group setting. It could possibly be just more of an intentional focus on the strategies that are implemented for that student. In other cases, we would move from tier 1. As we progress monitor, we kind of look at how students are doing to a tier 2 intervention, again, increasing those strategies and instructional times. I'm trying to think what else I was going to say there. That can happen in the gen ed classroom or in a learning assistance classroom. So it's tier 1 doesn't mean intervention classroom. It could be in either one of those places. And then for a few kids, we're really looking at intensive intervention to help them close that gap. And when deemed appropriate, may be in the form of a referral for an evaluation. I've attached on the slideshow, and I have it on the end of the slideshow as well, a decision tree from OSPI that can help teams kind of walk through that process as necessary or as needed. So talking about evidence-based practices, I'm really, really, really proud of the instructional coaching team. Last year, we had 7 instructional coaches go through the Institute of Multisensory Education in order to gain understanding of some multisensory strategies through Orton Gillingham. They brought back their expertise, and in some buildings, we've had the instructional coaches working with the paraeducators working with students in LAP, in Learning Assistance Program, or in the regular ed classroom, depending on where you're at. But also then working with classroom teachers. And in some buildings, they've utilized some of their building funds or their high poverty dollars to send their K-1-2 teachers to the multisensory training. So one thing I really wanted to make sure to note is that multisensory instruction is good for all students, but it is essential for some students. So when we talk about multisensory instruction, we're talking about things like tapping it out and blending, utilizing your body to do that. I was in a classroom today and I saw kindergartners punching out the sounds I saw students writing their letters in sand, saying the letter's name and the sound of the letter. I mentioned Orton Gillingham, but it's not the only program that has good multisensory instruction. There are lots of good multisensory strategies out there. We are also required, when a student is screened and at risk, to notify the family of the identified indicators of weaknesses. So again, I'm talking about phonemic awareness, phonological awareness, letter sound knowledge, and rapid automizing naming. So we have a drafted letter that we did use last year. We are also required to share that multi-tiered system of support plan and provide parental resources as published by the Superintendent of Public Instruction, and then to update the families on a regular basis of the student's progress. So that is always a work in, we did it, but we could always get better at it as well. So work in progress. So I indicated that we spent a good chunk of the year, we all did. We spent a lot of time updating our website. So I wanted to include that in here for you because I feel like I don't know how much it's been utilized. I put it together last year with a lot of information about the early literacy screening. It has a nice flyer that was set out during conference time last year when instructional coaches communicated to families. They didn't necessarily, some of them included this flyer, some of them included flyers from OSPI that had links to resources on them. Let me go back here. But that is a good flyer that's in English and Spanish for our families. It has information about the iReady diagnostic and the RAN. It looks like I need to update the year and when those are administered. And again, remember, we're really looking at early literacy screening being kindergarten through second grade. So we really want to find our students in kindergarten and first grade who have weaknesses in those areas and administer the RAN, and then catch any of our second graders that were either new to the district and we don't have any evidence that they've had that early literacy screener, or maybe they were missed. But by second grade, we want to make sure that they've had that early literacy screening. We've got some frequently asked questions on there, and then some additional information as put out by OSPI. So again, always looking to improve, but it's a great start for us and we're happy with it. Again, I included the decision tree for educators around the multi-tiered system of support. And then I do have a parent letter that when students, and for some reason, gives me a hard time there, that outlines that RCW, that their students showed weaknesses in those areas and that they'll be proceeding with intervention and a contact person that they can reach out to if they have questions. We try to send that out before conference time, so that encourages those families to come to conference, because kind of a little flag there for them. So, and that is my very quick presentation on the early literacy screener. Do you guys have any questions for me about that?
Unless I misheard you, or misunderstood, which is awesome. This is pretty much a K-8 program, it goes through. What about those kids that have fallen through the crack or transferred in that suffer from dyslexia, if you will, but have not been identified as a dyslexic child?
So we have actually had that conversation because obviously is concerning. Remember, we're not diagnosing dyslexia. We're just looking for areas of weakness or indicators of, and we're not sure this. So iReady is K-8, but the early literacy screener is K-1-2. So students above that grade level, if we haven't had the early literacy screener, my guess is they're probably already in intervention. When we looked at all the kids who we screened at risk, they were already in the learning assistance program. But what changed was the mode of delivery of intervention. So now we've incorporated the multisensory instruction. It was really fascinating because I went back through those lists to see, did we get anybody that wasn't already receiving some sort of intervention? And they were all already receiving either LAP intervention or they were students on IEPs that had risk factors as well.
The reason I asked that question is I have a family member who's deceased now in the county. And you work a manual repair manuals for whatever automobile. It'd take him 20 hours to read it,
Right.
but he'd fix the darn thing in 20 minutes. I mean, and that was over a long period of time. He learned how to make that up, but he never did get where he could read at any given speed to speak of.
Right. I am anticipating some guidance to come out around older students. I just don't know that it will be in the mode of a type of a screener. It might be more in the mode of strategies or interventions to utilize. Again, we're seeing really positive outcomes with students who are being exposed to multisensory instruction. And it's really fun and really engaging. The whole time I was watching that kindergarten class today, it was phenomenal just to see the engagement in the students. So, I hope that there are things that come about that we can implement and put into practice as well. So, good question. Thanks. Dave?
And dyslexia, that word has gone around for a long time. You've got screener for dyslexia. Do you tell parents that your child shows signs of dyslexia? Or do you say your child can't do this, can't do this, and can't do this?
I believe we never use the word dyslexia in our parent communication. We use risk factors or areas of weakness. And we might have said dyslexia, but if we did, it was risk factors for dyslexia, because again, we're not diagnosing dyslexia. So we're just making them aware that we see that they're struggling with phonemic awareness, phonological awareness, letter sound knowledge, or rapid automizing naming.
You're describing what.
Yeah,
areas of-
yeah. And then I think that they're going to have questions. And, when appropriate, a referral for an evaluation might be made. The state guidance talks a lot about a referral for a specific learning disability. That might be an appropriate referral, but it's a team conversation.
Is there a test for dyslexia?
There is, and I don't know enough about it, Dave. There is, and it has to be by a licensed psychologist. Outside, extensive, maybe even, help me out, Lucas, a psychiatrist. I'm not quite sure who does that diagnosing for dyslexia.
It's gotta be a doctor, maybe a pediatrician.
Yeah.
If you can't diagnose it.
Yeah. Any other questions? We really dug deep into this last year, and I think there's new guidance coming out all the time, but just trying to stay on top of it. So, thank you.
Okay, thank you for that prime presentation. We'll move on to item 7 on the agenda, public comment of non-discussion agenda items. If there's anyone who would like to speak. No one? All right, then we'll move past that to item 8, approval of consent agenda. There are multiple items. Let me look here if we can do them all together, or do we need to take them apart?
All together.
We can take them all together? Everybody okay with that? All right, then, we'll entertain a motion from someone to approve the consent agenda as presented.
I'll move to approve the consent agenda as presented.
Thank you, Mr. Thorner. We have a motion. We'll go ahead and vote. All those in favor signify by saying aye. Aye. Opposed, same sign. Motion carries 4-0. Moving on to item 9, action items, approval of travel requests. There are a couple there. Does anyone want to take those apart or have any questions? If not, we'll take a motion.
Just for the record, we're approving a travel request that already occurred.
Thank you, Mr. Thorner. That's correct.
I'll move to approve the travel request as presented.
Thank you. All those in favor signify by saying aye.
Aye.
Say, It's contagious.
My apologies.
Okay, all those not in favor, I lost my train of thought
Same
here.
sign.
Same sign, thank you. Okay, motion carries 4-0. Item 10, items arising.
Well, this might be a good time to share that we were able to attend the annual conference for the Washington State School Directors Association. And at the conference, there were certificates for each of our board members for recognition as WASDA Board of Distinction for 2022. So I'll go ahead and hand out these certificates for each of our board members.
Thank you.
Thank you.
Thank you.
Thank you.
All right, thank you, Dr. Finch, and congratulations, colleagues on the board, for a fine year of service. And I know the public appreciates it as well, but as board president, I want to express my gratitude and thank you as well. One other thing in items arising, I just more of an honorable mention. I noticed in one of the email messages we received that today was the, I think, first and only home girls wrestling meet. And I just took a little time out of my day to make sure I went to watch it, and it was very impressive. The parking lot was absolutely full. I was not expecting that. I went in and I thought maybe because this is kind of new to us, this would not be so strongly attended, but it was actually quite packed. I had to struggle to find a seat in the bleachers there. So just a shout out to the organizers and just the way the school has put this together, and it went very well. I was very impressed with what I saw. So the students were enjoying themselves, and I think we had 2 other school districts participating, Zilla and Toppenish, I think, or Sela and Toppenish. So a very nice event. So I just thought it was worth mentioning.
And this was at the junior high, right?
That was correct, at the
Yeah.
junior high.
Very good.
All right, item number 11, administrative reports. Dr. Finch, anything?
No, they were all provided in writing.
Okay. All right, enrollment report, safety report, travel log report, high school ASB report. Anything from anyone? There's several more.
Yeah, it looks like we're 130 some kids up.
Yep, still maintaining enrollment above projection, so that's good.
I went through we have all the schools send us a once a month a report on what they're doing. And my concern is that we have things going in all our schools, but in order to maintain fidelity in some of these programs, you have to stay on them.
Right.
You need to have continued training. And like at Tandem had Design and Learning, Universal Design and Learning, UDL, which is all throughout the district. They're working on that. Cottonwood was working PLCs, which is key to it. Mountain View was PBIS for the behavior management program that all of our schools used. White Hollow was working on inclusive practices. It's impressive to see how these people are staying on board. They're staying focused. And that has to happen in order to make sure that you have each of those programs is being run properly. And it looks like the principals are doing a great job of maintaining focus on those programs. At the high school, our athletic teams this fall, volleyball, soccer, football, girls swimming, girls and boys cross country, fall cheer, and soft pitch, all won awards for academic awards. Is either outstanding or distinguished. All those programs won awards this fall, which is great to see.
Yeah, and I appreciate Amy Forrest. In our flyer that's going to be mailed out to the community, we're highlighting the academic achievements of all the high school athletic teams. And yeah, it's great to see like you said, either the distinguished or outstanding. So that's really great.
And to echo Dave's thanks for the reports that we get from the schools. I read those every month too, and just like to, in addition to Dave's comments, echo my appreciation for the principals taking time out to do that for the school board. It's appreciated and noticed.
All right, thank you for those comments. All good comments and nice things to be aware of. All right, moving on to item 12, superintendent's report.
That was provided in writing as well.
Okay. Board reports, board development from anybody?
I'm involved in a continuing governance program related to another board that I sit on. But it's been, I think, quite beneficial to me, and I guess for using country boy terms like I do a lot, separating the harvest from the weeds. And I think, for what it's worth, this board is doing, or beginning to do a much better job of concentrating on the harvest and not as much time delving into the weeds. So I think for what it's worth, it's been beneficial to me, and I'm going to continue in it for another 6 months, I think. So I'm going to know enough to die one of these days.
Well, we hope you're around a lot longer, Mr. Meyer. Thank you for your comments. All right, we'll go ahead and break for,
I got a little bit here too.
oh, I'm sorry, go ahead.
I went to the Spokane conference like Peter did, and we saw some amazing work done by student representatives, presentations, and I mean, they got up and talked in front of 750 kids. And we need to get that going again now that we're done with the COVID and everything, and start working. And besides, and they made a good point, in the past here, they'd tell us when the football games were being played and when the dances were happening and things like that. The focus more was on letting them getting involved, and Peter asking them, what do you think about this? What do you think about that? Getting the student reps not only here, but also involved in the actual work of the school board. And I think that the ones that were involved that came to that conference were truly amazing kids. And I know we have the same thing here. We just have to get them utilized. And the second thing was, and I've heard this every time I go to a conference, I'm an old special ed director. The legislature doesn't fund special ed. And in the past, we always have heard, oh, yes, that's true, but we have these other things to do. At this legislature, the superintendent's group, the principals group, the teachers, everyone is united in going to the legislature and saying that the main source of needed improvement in funding is special ed. That is where the focus should be. And it's the first time that special ed has been a center focus on as far as funding. And it was really nice to hear. And maybe there's light at the end of the tunnel. That's it.
Okay, anyone else? One last call. All right, thank you, fellow board members, for those comments. All right, we will move into executive session. It is 7:36. I'd say about 15 minutes ought to do it. Is that good for everyone? All right, we will reconvene. No action will be taken. We'll reconvene here at 7:37, so that would be what, 7:52.
Or 3 if 7 and 6 is 13.
Sorry, what was that? So with that Meyer humor going on. Yes. Could you say it in the microphone for the record? Okay, I sure will. Executive session will be extended until 8 PM.
Oh, so we don't have a meeting tomorrow then, huh? That changes my schedule all the way around. In a good way. We'll wait for Mr. Thorne to come back and then I'll adjourn. If he's coming back in, he just sticks his head in the room. There we go. All right. Thanks everyone for being here this fine evening on November 21st. It's 8:05 and we will officially adjourn the meeting. All right, don't take off. I think there's stuff for everybody to sign. Here, I'll just start.